All rise. Court's now in session. Honorable Judge James C. Hankinson presiding.
Secretary, please.
Remain standing for the jury.
Everybody be seated, please. All right, good morning, folks. The next thing I'm going to do is instruct you on the law. You will be allowed to keep these written instructions, so you don't necessarily need to take any notes unless we find a typo or something. Despite the fact we go over them multiple times, we seem to always find some typo or some slight change that we've missed, hopefully nothing significant. What I would ask is that you read along with me as I go through them so that I can be certain everyone has been through them in their entirety on at least one occasion. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions I'm about to give you. Sigfredo Garcia and Catherine McManawa, the defendants in this case, have been accused of crimes of first-degree murder, conspiracy, and solicitation. First-degree murder includes the lesser crimes of second-degree murder and manslaughter, all of which are unlawful. A killing that is excusable or was committed by the use of justifiable deadly force is lawful. If you find Daniel Markell was killed by the defendant, you will then consider the circumstances surrounding the killing in deciding if the killing was first-degree murder or was murder in the second degree or manslaughter, or whether the killing was excusable or resulted from justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any one of the following three circumstances. When the killing is committed by accident and misfortune, in doing any lawful act by lawful means with usual ordinary caution and without any unlawful intent, or when the killing occurs by accident and misfortune in the heat of passion, upon any sudden and sufficient provocation, or when the killing is committed by accident and misfortune resulting from a sudden combat, if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. Dangerous weapon is any weapon that, taking into account the manner in which it is used, is likely to produce death or great bodily harm. In count one, Sigfredo Garcia and Catherine McManawa, the defendants in this case, have been accused of the crime of first-degree murder. To prove the crime of first-degree premeditated murder, the state must prove the following three elements beyond a reasonable doubt. 1, Daniel Markell is dead. 2, the death was caused by the criminal act of the defendant. 3, there was a premeditated killing of Daniel Markell. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection by the defendant. The premeditated intent to kill must be formed before the killing. The question of premeditation is a question of fact to be determined by you from the evidence. It will be sufficient proof of premeditation if the circumstances of the killing and the conduct of the accused convince you beyond a reasonable doubt of the existence of premeditation at the time of the killing. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he or she is accused, there may be evidence that he or she committed other acts would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicate the definition of first-degree murder are second-degree murder and manslaughter. To prove the crime of second-degree murder, the state must prove the following three elements beyond a reasonable doubt. 1, Daniel Markell is dead. 2, the death was caused by the criminal act of the defendant. 3, there was an unlawful killing of Daniel Markell by an act eminently dangerous to another and demonstrating a depraved mind without regard for human life. An act includes a series of related actions arising from and performed pursuant to a single design or purpose. An act is eminently dangerous to another and demonstrating a depraved mind if it is an act or series of acts that a person of ordinary judgment would know is reasonably certain to kill or do serious bodily injury to another and is done from ill will, hatred, spite, or an evil intent, and is of such a nature that the act itself indicates an indifference to human life. In order to convict of second-degree murder, it is not necessary for the state to prove the defendant had an intent to cause death. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Daniel Markell is dead. 2, the defendant intentionally committed an act or acts that caused the death of Daniel Markell. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. If you find that the defendant Garcia committed second-degree murder or manslaughter, you will be asked to find beyond a reasonable doubt whether during the commission of the crime, the defendant Garcia personally used a firearm. You should designate this finding on the verdict form. If you find the defendant Garcia committed second-degree murder, and you also find beyond a reasonable doubt that during the commission of the crime, the defendant Garcia discharged a firearm or actually possessed a firearm, and in doing so caused death or great bodily harm to the victim, you should also designate this finding on the verdict form. A firearm is legally defined as any weapon, including a starter gun, which is designed to or may readily be converted to expel a projectile by the action of an explosive, the frame or receiver of any such weapon, any firearm muffler or firearm silencer, any destructive device, or any machine gun. To actually possess a firearm means that the defendant Garcia personally carried a firearm on his person or had a firearm within immediate physical reach with ready access with the intent to use the firearm during the commission of the crime. There are two ways in which a person may be a principal. If the defendant helped another person or persons commit a crime, that defendant is a principal and must be treated as if he or she had done all the things the other person or persons did. If that defendant had a conscious intent that the criminal act be done, and that defendant did some act or said some word which was intended to, and which did incite, cause, encourage, assist, or advise the other person or persons to actually commit the crime. The defendant may also be a principal if he or she paid or promised to pay another person or persons to commit a crime. The defendant is a principal and must be treated as if he or she had done all the things the person who was promised or received the money did if that defendant had a conscious intent that the criminal act be done, and he or she made or promised the payment in exchange for the commission or promised to commit the crime or to help commit the crime, and the crime was committed by the other person. To be a principal under either theory, the defendant does not have to be present when the crime is committed. If you find that the crime of first-degree murder was committed, an issue in this case is whether the crime was an independent act of a person other than the defendant. An independent act occurs when a person other than the defendant commits or attempts to commit a crime which the defendant did not intend to occur and in which the defendant did not participate, and which was outside of and not a reasonably foreseeable consequence of the common design or unlawful act contemplated by the defendant. If you find the defendant was not present when the crime of first-degree murder occurred, that in and of itself does not establish that the first-degree murder was an independent act of another. If you find that the first-degree murder was the independent act of another, then you should find the defendant not guilty of the crime of first-degree murder. In count 2, Sigfrido Garcia and Catherine McManawa, the defendants in this case, have been accused of the crime of conspiracy to commit first-degree murder. To prove the crime of criminal conspiracy, the state must prove the following 2 elements beyond a reasonable doubt. 1, the intent of the defendant was that the offense of first-degree murder would be committed. And 2, in order to carry out the intent, the defendant agreed, conspired, combined, or confederated with another person to cause first-degree murder to be committed, either by them or one of them or by some other person. It is not necessary that the agreement, conspiracy, combination, or confederation to commit first-degree murder be expressed in any particular words or that words passed between the conspirators. It is not necessary that the defendant do any act in furtherance of the offense conspired. In count 3, Sigfrido Garcia and Catherine McManawa, the defendants in this case, have been accused of the crimes of solicitation to commit first-degree murder. To prove the crime of criminal solicitation, the state must prove the following 2 elements beyond a reasonable doubt. 1, the defendant solicited one or more persons to commit first-degree murder. 2, that during the solicitation, the defendant commanded, encouraged, hired, or requested one or more persons to engage in specific conduct which would constitute the commission of first-degree murder. It is not necessary that the defendant did any act in furtherance of the offense solicited. To solicit means to ask earnestly or to try to induce another person to engage in specific conduct. Voluntary intoxication resulting from the use of alcohol or a controlled substance is not a defense to a crime. Evidence of a defendant's voluntary intoxication may not be taken into consideration to show that he or she lacked the specific intent to commit any crime. A person is voluntarily intoxicated if he or she knowingly consumed a substance that he or she knew or should have known could cause intoxication. The defendants have entered a plea of not guilty. This means you must presume or believe the defendants are innocent. The presumption stays with the defendants as to each material allegation in the information and indictment through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crimes with which the defendant are charged were committed, and the defendants are the individuals who committed the crime. The defendants are not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if after carefully considering, comparing, and weighing all the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendants may arise from the evidence, conflict in the evidence, or the lack of evidence. If you have a reasonable doubt, you should find the defendants not guilty. If you have no reasonable doubt, you should find the defendants guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things you should consider are, did the witness seem to have an opportunity to see and know the things about which the witness testified? Did the witness seem to have an accurate memory? Was the witness honest and straightforward in answering the attorney's questions? Did the witness have some interest in how the case should be decided? Does the witness's testimony agree with other testimony and other evidence in the case? Excuse me. Has the witness been offered or received any money, preferred treatment, or other benefit in order to get the witness to testify? Had any pressure or threat been used against the witness that affected the truth of the witness's testimony? Did the witness at some other time make a statement that is inconsistent with the testimony he or she gave in court? Has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it is called or upon the number of exhibits it is offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his or her testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his or her opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him or her to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. You must consider the testimony of some witnesses with more caution than others. For example, a witness who claims to have helped the defendant commit a crime, has been promised immunity from prosecution, or hopes to gain more favorable treatment in his or her own case, may have a reason to make a false statement in order to strike a good bargain with the state. This is particularly true when there is no other evidence tending to agree with what the witness says about the defendant. So while a witness of that kind may be entirely truthful when testifying, you should consider his or her testimony with more caution than the testimony of other witnesses. However, if the testimony of such a witness convinces you beyond a reasonable doubt of the defendant's guilt, or the other evidence in the case does so, then you should find the defendant guilty. One of the defendants has become a witness. You should apply the same rules to consideration of her testimony that you apply to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. The Constitution requires the state to prove its accusations against the defendants. It is not necessary for the defendants to disprove anything, nor are the defendants required to prove his or her innocence. It is up to the state to prove the defendant's guilt by evidence. One of the defendants exercised a fundamental right by choosing not to be a witness in this case. You must not view this as an admission of guilt or be influenced in any way by his decision. No juror should ever be concerned that the defendant did or did not take the witness stand to give testimony in the case. A statement claimed to have been made by one of the defendants outside of court has been placed before you. Such a statement should always be considered with caution and be weighed with great care to make certain it was freely and voluntarily made. Therefore, you must determine from the evidence that the defendant's alleged statement was knowingly, voluntarily, and freely made. In making this determination, you should consider the total circumstances, including but not limited to whether when the defendant made the statement, he had been threatened in order to get him to make it, and whether anyone had promised him anything in order to get him to make it. If you conclude the defendant's out-of-court statement was not freely and voluntarily made, you should disregard it. These are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. You must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of the witnesses and have seen in the form of the exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendants have been proven guilty or not in accord with the law. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. The jury is not to discuss any question that a juror wrote that was not asked by the court and must not hold that against either party. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. Please disregard anything I may have said or done that made you think I preferred one verdict over another. A separate crime is charged against each defendant in each count. The defendants have been tried together. However, the charges against each defendant and the evidence applicable to him or her must be considered separately. A finding of guilty or not guilty as to one of the defendants must not affect your verdict as to the other defendant or other crimes charged. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then of course your verdict must be not guilty. The verdict must be unanimous. That is, all of you must agree to the same verdict. Only one verdict may be returned as to each crime charged. The verdict must be in writing, and for your convenience, necessary verdict form has been prepared for you. There are two verdicts. All right, so everybody should have two verdict forms. Everybody have two verdict forms. Let's start with the one titled Sigfrido Garcia. There's slight difference in the verdict forms. We'll make sure to point that out. I think it's pretty self-explanatory, but let's look at the verdict form. As to count one, you have four choices. Either A, guilty of first-degree murder, B, guilty of second-degree murder, C, guilty of the lesser manslaughter, or not guilty. You need to make a unanimous decision as to which of those verdicts you decide as to count one as to Mr. Garcia. You'll see there's an interrogatory there. If you choose either first-degree murder or not guilty, you don't have to worry about the interrogatories. But if you choose second-degree murder, you need to answer the interrogatory during the commission of the offense designated above. The defendant discharged a firearm causing great bodily harm or death, discharged a firearm, actually possessed a firearm, or did none of the above. You would work from the top and work down. You would check the most serious option proven, which it starts at the top with most serious. If you choose B or C, and that may be slightly confusing if you choose B, but if you choose B or C, you need to answer the next interrogatory. During the course of the offense designated above, the defendant used a firearm, yes or no. That would be as to count one. As to count two, it's fairly straightforward. The defendant is guilty of conspiracy to commit first-degree murder or not guilty. You would sign the unanimous choice of the jury. As to count three, the defendant's guilty of solicitation to commit first-degree murder. The defendant's not guilty. You would check the unanimous decision of the jury. It would be signed and dated by the foreperson. The foreperson will bring the verdict form back to the courtroom after you've completed your deliberations. Sometimes I get a question from the jury as to whether everybody has to sign the verdict form. No, the foreperson signs on behalf of the jury. Now let's look at Ms. Magbanowa's verdict form. It's essentially the same, except there are no interrogatories. You don't have to worry about any interrogatories as to Ms. Magbanowa. So you have to count one, either A, first-degree murder, B, second-degree murder, C, manslaughter, D, not guilty. Again, you would check the one option the jury unanimously agrees upon. And count two, it's either conspiracy to commit first-degree murder or not guilty. And on count three, it's same, either guilty of solicitation to commit first-degree murder, not guilty, be dated and signed by the foreperson. So when you get through, you should have 3 check marks on the verdict form there and be signed and dated by the foreperson. I'll give my concluding remarks after the attorneys have made their closing arguments. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instructions on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defendants have spoken. So the order will be, the state will make argument, Garcia make argument, McFadden will make argument, and then the state has the opportunity to make a rebuttal argument at the end. Ms. Kaplan?